This matter is the Associated Press versus the Washington State Legislature. Paul Lawrence will open for 15 minutes, reserving 5 minutes for rebuttal. Michelle Earl Hubbard will have 20 minutes for response. Counsel.
Thank you, Your Honor. May it please the Court, Paul Lawrence for the Washington State Legislature. This is a case purely of statutory interpretation. It raises two questions: whether the legislature and its members are state agencies as defined in the Public Records Act. The answer to that is no. And is the scope of the legislature's obligations under the Public Records Act limited to define legislative records to be administered by the Secretary of the Senate and the clerk?
Do you acknowledge that the legislators have ever been an agency, determined to be an agency?
I think that certainly originally when the definition included public official, they certainly would have been. I think it's a closer question during the period up until 2007, but clearly where we are now, given the amendments to the definition of agency in the Public Records Act and looking at what the legislature did with respect to the definition of agency in the Ethics Act and the Campaign Finance Act, the plain meaning is clear now that the legislature is not an agency.
So would you say 2007 was the clean break, so to speak?
Yes, that's when the specific definition was adopted for the Public Records Act that did not include specific definitions of state office that included the state legislature, which had been previously been in the Act. The trial court and the media made two fundamental errors in applying the plain meaning analysis. First, they refused to give way to the amendments that we were just talking about. And this court has made clear that part of the plain meaning analysis includes the consideration of amendments to the Act.
Why didn't, if it was so plain, why didn't the legislature just say, this doesn't apply to us?
You're talking about the amendments in 2007? To me, it was plain that if they were saying that by not incorporating the definitions. If you look at the definitions in the Campaign Finance Act.
But clearly it's been confusing to people who've tried to construe what it means after the fact. And so I'm just wondering, you think that the clear intent, no, without getting to the intent, you think the clear language itself on its face should let everybody know that there's intended to be an exception for the legislature?
First of all, I don't think there's been any confusion on this. There's no history that, actually since 1995, that the legislature has accepted that it is covered by the Public Records Act. If you look at the declaration of Jeannie Gurel, she testifies that the practice from 1995 has been consistent and attached to House rules. So I'm not sure there's confusion. But I think in trying to understand what the plain meaning is, you look at the text, you look at the amendments, and it's hard to imagine something clearer than when you say, okay, you take away the definition that included legislative offices, you take the definition, away the definition that included the offices of the legislature, et cetera, and put those only in the Campaign and Ethics Act. And it's as clear as it is with respect to the judiciary. The holding in the case that held the judiciary was not subject to the Public Records Act made the point, look, it didn't say judiciary in the definition of agency. Well, it doesn't say state legislature in the definition of agency either.
You think it's the same analysis and not the separation of powers or the constitutional arguments you say aren't in this case that leads to that conclusion?
Well, there's the analysis that was done with respect to the judiciary was a multiple-part analysis that first started with the text of the statute. It then looked to whether or not, for example, the Constitution allowed the judiciary to set its own rules, and the court looked at that. And in this case, the Constitution allows the state legislature to set its own rules. The court also looked at whether or not the Constitution had some requirements for record-keeping for the judiciary. And similarly here, the Constitution requires certain legislative records be kept open and available to the public. So the analysis is really on all fours with the analysis that was done of the judiciary, in which this court found the judiciary.
Wouldn't it have been simpler for this court to say in one of those cases in Naster and Koenig that the Public Records Act applies only to executive branch entities? Because that's essentially the end result of your argument.
Well, Yes, if that issue had been addressed directly to the court, but I don't think that question has been addressed directly to the court. I will just note that we don't take the position that there's no aspect of the Public Records Act that applies to the state legislature. The state legislature, in its own right to determine what goes in and out of that, has said that there are certain legislative records that are defined as public records under the Act, and that those have to be made available.
But what's odd about that to me, and maybe this is part of the way the case was divided at the trial court, is that's a definition of what is a record. But you start with the definition of who is an agency. And I don't know why we'd even get to what's a record if we don't even have an agency. And yet it's odd that